I'm Susan Grissom with Grissom Law Firm. We're located in Johns Creek, Georgia, and I'm licensed to practice law in the state of Georgia. Our firm is focused in the areas of estate planning, uncontested probate, and small business law. Today, I want to answer a question that I get quite a bit, and that's an assumption that on death, if you don't have a will or a trust in place, the state will take your assets. I have this question quite frequently from individuals, and that's just simply not the case. Instead, the state law will dictate who receives your assets. I'm going to spend just a couple of minutes explaining what I mean by that. So when an estate is opened and there's no will in place or trust in place, we're doing what's called an intestate probate, meaning you didn't write a will to dictate who's going to be the beneficiary of your estate. Under that circumstances, the state of Georgia has dictated who your heirs are, and those are the people who are going to receive your assets upon your death. If you're married and have no children, your spouse is your heir. If you're not married and have no children, your parents are your heirs. Or if you're not married and have children, your children are your heirs or their children, and if any of them have predeceased you. In these instances, if I have multiple children, we're going to split equally to the children. And if I have a deceased child, their share is going to flow down to their children and be split. It gets a little bit more interesting if I'm married with children and I don't have a will. In this instance, we're going to split between the spouse and the children, and many people don't realize that. Many people just assume that their spouse would receive their estate, and that's just simply not the case. In this instance, the spouse never receives less than a third, but if there are two children and a spouse, 1/3 each. If we have more than 2 children, we're going to give the spouse a third, and we're going to take the other 2/3 and we're going to split among the children and then down to their descendants if any of them have predeceased us. This is one of the things that sometimes happens where we see minors receiving assets in probate because there was no will in place, and the parent just assumed, the surviving parent, that they would receive all of the assets, and now they have to have a conservatorship established so that those minors' funds can be managed, and at age 18 they're turned over to the minor child. If we don't have a spouse, children, parents living, the next people that we're going to walk out to are going to be our siblings and then our nieces and nephews. For some people, their heirs are the right people to receive their assets. For most people, that's not the case. We work with people to determine who are the correct individuals. That's why you want a will, to name those beneficiaries and leave them to the correct individuals or charities if that's your choice and your selection. If we can help you with this, give us a call. We're happy to assist.